Hi, everybody. We're just letting everybody in for this hot topic. Hope everything's safe and sound where you are. The last of the snow is melting, knock on wood, in Chicago. So that always puts an extra spring in my step.
That's the last of the February snow. Wait until the March snow comes.
Yeah, wait till the St. Patrick's snow, right? Okay, we'll give people another 60 seconds because you all know people come running right at the appointed hour, and we might as well let them all come running in the door. John, this might be a good time to plug the upcoming 15th annual West Coast Meeting of the Minds Conference. John, I think we need our heads examined, but we've wound up with 50 sessions and 60 speakers.
It's a record.
At a crazy cost of $195 per institution. It's like giving away profound knowledge, but
hey, and I just had a phone call a little while ago. Somebody asking if we were going to be able to offer CFRE credits, and the answer is yes. We're waiting to hear back from the CFRE people, but yep, we'll get them out.
They talked to CFRE man, that's for sure.
That's right.
Okay, the number of people running is slowing down a little bit. So just give me another couple seconds and we'll introduce our guest, and we'll have a discussion all about this topic. Well, I was going to say, John, for Meeting of the Minds, this is the first one I can recall where the opening session will require 3D glasses. I'm not kidding. So come and join us. We'll have a lot of fun, lots of great information, and anywhere you are. Okay, I got 4 more people I'm going to admit, and I'm going to let you two do most of the talking while I just keep an eye on the chat and all that stuff. John, this is also kind of our anniversary. This was a year ago that John and I had 250 people signed up for the West Coast Meeting of the Minds, and I'll never forget the day that Tom Hanks announced he had tested positive with his wife, and the NBA shut down its entire schedule. And I messaged John somewhere in the middle of all that and said, do you think we're going to have a problem with 250 people in Pomona? And John said something to the effect of, he's sensitive that I tease him about this now. He said something to the effect of, oh, I'm sure it'll be fine.
It'll be fine.
And not 2 weeks later, we were sort of a Zoom guinea pig. I had no idea even what the Zoom buttons did. John still doesn't. But everything went fine. In a way, this session today is kind of an offspring of the realization that you could get people together for a chat like this and involve experts like we have with Nathan. And so this is just the latest installment of Bob and John trying to figure out sharing knowledge on Zoom. So John, good afternoon.
Good afternoon. How are you?
You're in Durham, North Carolina, right?
Durham, North Carolina, where the sun is shining, the flowers are beginning to bloom, and the dog is probably going to start barking any minute.
Why would today be any exception?
I don't know. I have no idea. But looking forward to seeing you in Pomona in just 1 month.
If you're not familiar with John's and my history, I am an old annual giving, relentlessly enthusiastic marketing man, idea man. John is the advancement services side of the house, a little more risk management conscious, a little more rules conscious.
More rules.
He can tell you IRS guidelines and tax deductibility and in-kind gift valuations till the cows come home, and frankly does it better than anybody I might have imagined tolerating. So we've been chuckling about why we haven't thought about this subject before, because this has the potential to be the most depressed I've ever been at one of our joint conversations. And foolishly joining us today from Kansas City, I believe, where the South meets the West, is Nathan Thomas, who's joining us by phone. He doesn't want to be visually associated with this at all, I don't believe, and I don't blame him. Nathan, welcome to this sorry duo, and thanks for joining us today.
Oh, it's my pleasure. Thank you for having me. I look forward to the conversation.
Would you say a few words about your firm? Nathan and I figured out that I probably reached out to one of the founders of his firm 25 or 30 years ago when state registrations were still relatively new. And I'm embarrassed to say I've missed a little bit in the firm's history since then. But say a little bit about where you are and what you guys do, and maybe a little bit about you specifically.
Yeah, we're a boutique law firm located in Kansas City, Missouri. And we represent hundreds and hundreds of nonprofit tax-exempt charitable organizations, including many colleges, universities, hospitals across the country. And we are specialized in fundraising compliance, primarily at the state level, which we'll talk about today. And I know some of you will have questions related to what's required for engaging in fundraising nationwide. And that's what we specialize in. We like to say we know a lot about a little because we do know quite a bit about a small area related to state compliance and fundraising.
And we're thrilled that you're here. John and I had a disclaimer on every single slide that we are not attorneys.
and so don't want to be attorneys.
So you bring some important credibility to this conversation. John, as is his nature, has put together some factual, straightforward information on this subject. And Nathan has complete free range to amplify anything John says, certainly correct anything John says, and otherwise be available as we go to field any questions that I'm sure a lot of us will have, including me. So I get to kind of be a little bit of a wingman here and watch these two get on well with each other. But use the chat, post any questions. I think I already got one submitted even before we started. And if any of you saw that we were inviting responses to a survey, as I kind of predicted, we got just a few responses, and mostly people who didn't really want to talk too publicly about how they're handling state registrations. I'll reference a couple of those as we go, but for the moment, I think I'm going to shut up and let a few more people into the room and let my buddy John do what he does best, which is present information. John, are you ready to go?
I'm as ready as I'll ever be.
All right, I'm going to push the button.
Push the button away. When Bob said that I had some straightforward factual information, Bob's polite way of saying boring. And I honestly, I couldn't think of a way to make this really exciting and enticing. But Bob and I have, from both of our walks of life, the annual giving walk of life and the advancement services walk of life, we hear about state registrations and requirements a lot. And it's really more people deer in headlights, confused. Do I need to do this? Oh my God, I just received a letter from the Attorney General of the state of Mississippi saying they're take our revenue of last year. So what we thought we would do is lay out some factual information. What you see on the screen is some of the minimum stuff that we will attempt to cover. Bob and I are not really advocating one way or another how to do, what you need to do, or should do. I think one of the four-letter words you will hear frequently throughout this conversation is it's all about risk. A bit of background, though, just to fill you in, that I really was only on the periphery of this kind of thing when I was at Duke University. I knew that Duke University did something with state registrations, but it was not done in my office. And that's one of the things that we were trying to find out is, for those of you that are doing this, what office is doing it. When I arrived at NC State, though, it became a pretty big deal because it really was not being done in a cohesive manner. And to really make matters difficult for us at NC State is we had 11 foundations. And 11 foundations doing their own fundraising. And University Council, who was not aware that we were not registering, said, yeah, you probably need to register. And so it was then, in 2008, that I took it upon myself to learn an awful lot about this. I don't know what the status is at NC State now, but in 2013, when I left, we were registering in every single state that required it, as long as we had somebody in that state that we were actively cultivating or soliciting. We can talk a little bit, or maybe Nathan can chime in about, well, what if you're not actively soliciting, but you allow people to make online donations from different states? Anyway, we'll move on. These are the topics that we're going to cover. And Bob, let's go. Yeah, Nathan.
Yes.
Did you have a comment?
Yeah, I think it's important to note that the act of soliciting itself is what triggers these registration requirements. So, for example, let's say I'm a university in Nashville and I direct appeals or solicitations to Mississippi, whether it's by telephone, mail, in person. I have to register prior to sending those solicitations. Conversely, if I'm in Nashville and I don't direct any such solicitations to Mississippi, but someone there is an alumni or they know about the university and like it, and they subsequently just randomly send me a check for $100, then I'm not required to register in this state, because even though I received a contribution, I didn't solicit it. So it's directing the solicitation to the state that's what triggers these registration requirements.
Thanks, Nathan. Let me answer one quick question. I meant to cover this. Somebody asked about the 11 foundations at NC State. And whether or not the university, quote unquote, handled all of the answer is no. My office, so I was the Associate Vice Chancellor for Advancement Services. My office had the responsibility for handling registration for the university, for the North Carolina State University Foundation, and our Alumni Association, which was part of university advancement. By mandate issued by University Council, all of the other foundations were required to handle their own registration. So, Bob, let's go to the first slide and we'll get into this really boring stuff. So the question is, do we really have to register? And do we have to register in every state? And the answer is, and again, Nathan can shoot me down here.
So when I said, you've got to register prior to soliciting, that's the general rule. And then under the state charitable solicitation acts, they carve out certain exemptions from the registration requirements. And one of those is for educational institutions. Now, what's frustrating about the educational institution exemption is that it varies significantly among the states. So anyone or any advice that you've received from anyone that says, oh, we're a university or university foundation, we don't have to register because we're exempt. That is incorrect information. It may be true in a couple of states or a few states, but in order to determine whether or not you can enjoy an exemption from registration in the state, you have to look at actually each respective state's exemption statutes. And unfortunately, they're not necessarily as broad as we like. The good ones, for example, would say any educational institution that solicits contributions is not required to register. But unfortunately, they're not all that broad. Some of them, for example, might say that educational institutions are not required to register only if they direct solicitations to their alumni or something like that. The problem is, how many institutions actually limit their fundraising to their alumni? Not many successful ones. I know they're always soliciting corporations or other organizations or grants from the government or otherwise. So you've really got to be careful to make sure that you fit within each respective state's exemption. In fact, most of the organizations that our firm registers or files on behalf of usually typically registers between 15 and 18 states, because of the limitations related to those exemptions. Some of them are also strange and say things like educational institutions are exempt unless they use outside fundraising vendors or something like that. Or they might say as long as solicitations are conducted by unpaid individuals, or strange language that is not reflective across the board in the state laws. But again, unfortunately, we're stuck with looking at each particular state statutes, also looking at who you're soliciting and how in order to determine whether or not you're able to enjoy each respective state's exemption.
And then let's talk a little bit about the exemptions, and let me dovetail on that. I mentioned here that some states do, and you mentioned this as well, some states do allow for an exemption for educational institutions. It's not automatic. It may be automatic in a couple of cases. I can't recall right now. And one of the things that you do need to understand is that the rules change a lot. So one of the reasons why we at NC State decided to use a third party for handling is it's pretty hard to stay on top of all of the rules and regulations of every state, and the District of Columbia has its own registration requirements as well. So number one, yes, there are exemptions for educational institutions, but it's not automatic. You do need to sometimes file. As was the challenge for us, not a challenge, but the issue for us at NC State is that we did very, very little fundraising or solicitation in the name of NC State. All of our fundraising activity was performed in the name of the North Carolina State University Foundation. While states may have an exemption for educational institutions, not all of those states have exemptions for their affiliated organizations. So you have to dig even deeper into what does the state allow, disallow, that type of thing. I also wanted to mention here before we get too deep into all of this, we're only talking about the general fundraising, registration, solicitation requirement statutes of states. We're not talking about the different registration requirements that there are for deferred giving, and in particular, charitable gift annuities, which is another kind of registration requirement and can be extremely expensive. Also note this last bullet on this particular slide is that if you hire a fundraising consultant or a vendor, they also must register as a company operating on your behalf. So you may want to make sure that they are doing what they need to do, because in fact it is often their registration with a state that will raise a flag at the Attorney General's office that says, "Ooh, NC State has hired XYZ firm to do phonathons in our state, but we don't have a registration from NC State University." So
I think I can't emphasize that last bullet point enough, because it is how most of my charitable organization clients, and when I talk about charitable organizations generally, I'm also including universities, colleges, and related foundations. This is how they get on the radar of the attorneys general or the secretaries of state or the agency that regulates these registration filings. What happens is you hire an outside vendor to either perform fundraising or fundraising consulting. And those vendors are required under the state laws to file their contracts with you, with the states. And one of the first things the state charity regulators do upon receiving those contracts from the vendor is to check and see if the charitable organization with which it contracted is registered or enjoys an exemption within the state. I just recently had this come up in Kentucky for one of my vendor consultant clients that was filing a number of university and college contracts. And Kentucky was coming back and rejecting the contracts because the universities and colleges weren't registered and did not request an exemption. What was frustrating about the situation is that there's no Kentucky law or rule that requires a university or college to request an exemption, but it's what we call a self-actuating exemption, meaning the state law just says, colleges or educational institutions aren't required to register, and there's nothing that a lawyer or any reasonable person would see that would say, well, I have to write a letter to the state asking for an exemption. So Kentucky was rejecting the vendor contracts and then making the vendor go to the universities and colleges and say, look, I can't fulfill my legal obligation until you either register with the state of Kentucky or write a letter to them claiming the exemption. So that just goes to the point that, you've got to be careful. Even if the state law is clear that you're exempt, that doesn't mean that the regulator isn't expecting you to request that they confirm the exemption.
Right. Bob, unmute yourself.
Senior moment. I just knew you and Nathan were going to get along well in this, and I'm getting a small pile of questions here. Do you want to take any as we go? Do you want to hold until the end?
I was going to take one, and then I'm going to let you, because you're right. There's a bunch of them, and so throw them out whenever. But let me get to Kim's real quick, and that was simply when you register on behalf as the foundation, that is the entity that you have to solicit under. If you are going to solicit as a university, then you also have to register as a university or as an alumni association or as a separate athletic association, that type of thing. Michelle, the states that are exempt and the like, we don't have time to go into this, and it does change every year. But what I can tell you is that there are resources out there. Giving USA publishes an annual guide, but also the National Association of, what's it called? Nathan, help. National Association of State Charity
Officials.
NASCO, thank you. You can go to that website and download their guide, and it will help you. Case, if you are a member of the Council for Advancement and Support of Education, actually has a 42-page white paper that explains all of the requirements for every state. But Bob, let's go ahead and move on to the next slide, or else we're going to be here on Thursday. So the rules, unfortunately, are different pretty much with every state as far as what you need to do, how you need to do it. I had fun trying to find some weird state laws. This is actually a state law. You cannot go enter the state of Wisconsin wearing a chicken on your head, but that doesn't apply to state registrations. And this is one of somebody asked, that this is a full-time, whether or not this is a full-time job. It is, especially when at NC State with all of these foundations, which is why we decided outsource, and we'll talk about that in just a minute. Staying on top of all of the different requirements. Bob, go ahead and go to the next slide.
I wonder how this became a law, by the way, and we should add, we really threw Nathan yesterday with what this slide was doing in the presentation at all.
It's true.
So to the earlier question, the 41 states that have some kind of a requirement, including filing for an exemption, have different rules. Now, there is this unified registration statement, and there's a URL there that this is kind of, I look at this kind of like the Common App. So, I mean, you can fill out this one form and almost all states will accept it, but they'll accept it plus additional information. So it's not just the Common App. 20 states require additional information on top of the multi-state form. And again, that PDF is the actual form you can complete, but you still have to file that form with every state, following their rules with your check or checks. Somebody asked, is this annual? Yes, you have to renew your registration on an annual basis. There are a few states, the last time I looked, you had to renew every 6 months, I think it is. But there's the form that you need to state or a renewal application, an annual fee, and then every year you have to do the kind of thing. And not every state has the same time frame for when you need to submit it. Some are based on when your fiscal year ends, and you have to include, and we'll see it in a second, some financial information from your institution. Some are based on the state's fiscal year. Some are based on a calendar year. Some have a grace period of 45 days or 30 days. There's no one set of rules. Bob, do you have a question that you wanted to throw out?
I'll just pick one for the moment. Oh, a good question about if somebody makes a memorial gift in memory of somebody to your organization, and they're in some state that maybe you weren't even actively soliciting people there, but now do they have to like sort of backfill and register just because they kind of passively received a gift from somebody?
Well, again, the registration requirements pertains to obtaining permission to ask for money in that state. So in theory, you could, and Nathan can jump in a sec, in theory, you wouldn't need to retroactively register because you didn't actively solicit that particular gift. But if that donor now goes on to your direct mail list, you will need to register in that state going forward.
Let me just ask this, and then I'll let Nathan jump in if he wants to. Active solicitation kind of becomes an important phrase, doesn't it? There's another question about any online fundraising you do that could inspire a gift from any of the 50 states. Sort of a similar question, isn't it?
Yeah, so one of the main problems with my charitable organizations that say, well, let's see, I only have my major donors are in a handful of states. So I'm going to register in California, Illinois, New York, Texas, and let's say they register in like 7 or 8 states because that's where they've identified their primary donor base. And in order to save costs or administrative burden or whatever they decide, that's what they decide. What happens is, and how they get in trouble is, let's say they randomly get a $100 gift from Utah and they weren't registered in Utah, but then that new donor goes on their donor list, and then they subsequently get charitable solicitations. That's how they get in trouble, is that while they had good intentions on the front end, once that new donor gets on the list and you start mailing them, you have to register prior to soliciting that person in the state where you're not registered or exempt. So that brings us to the internet question, which is still very confusing to most. And also the states haven't given us a lot of guidance. And I say that because I think only Mississippi, Tennessee, and Colorado have some sort of rule guidance related to the situation where you're not directing any solicitations to a state, but you maintain a website whereby individuals can go to your website and make a contribution. So the question is, if I'm not directing any appeals to a state, and the only way somebody can give to my organization is to go to my website and donate now, am I required to register in that state? And the answer is no, unless, number one, are you specifically calling for contributions from the specific state? People of Tennessee or people of Nashville, please give to me. We really want you to do it. If so, then you'd be required to register. If you're not doing that, the second thing you want to look at is to what extent you're receiving contributions from the state. Is it significant and ongoing? And what does that mean? Well, again, only 3 states, Mississippi, Colorado, and Tennessee, have provided any guidance on that issue. But the states have published or sent out guidance called the Charleston Principles, which were issued in the year 2001. And believe it or not, that's the most recent guidance we have. It's from 20 years ago. And so that guidance basically says that if you don't receive contributions on a significant and ongoing basis from a state, and that means about $25,000 or more from the respective state, then you would not be required to register. What's a problem with that is it's just merely guidance. It's not a statute or rule. So the safest thing to do is to register once you start getting that amount of money from a state, or make sure you're able to enjoy the exemption if you're an educational institution in that respective state.
Okay, Bob.
On to the next.
Yep. So again, adding insult to injury, not every state requires the same material. This is just a sampling of the kind of material that a state may require you to submit, at least upon initial registration. Once you've gone through it the first time, not all of the states are going to require that you resubmit all of this material every year, although some states do ask for an updated list of your board members, as you see in the bullet on the left-hand side. They may ask for IRS Form 990, and then there are a number of states that have their own specific forms that you have to complete, either both at registration and annual resubmission, or just an annual resubmission. And let me answer this question just popped in. We're talking about educational organizations. These laws apply to any charity that solicits money. There's not a separate set of rules for hospitals or arts and cultural organizations or higher education or K through 12. The rules apply to any nonprofit organization that wants to raise money in any state. Now, I probably just burst somebody's bubble.
Shocking.
I know, that's, I'm used to that.
Hey, Nathan, when we talked yesterday, you brought up the phrase risk tolerance. And can you talk about what that means in this context? So we got a question. Somebody says, this seems like a full-time job. Do we have to really concentrate on this every year? I mean, obviously, getting a third party involved is one solution. But when you say risk tolerance, and people are evaluating, do I need to register in 50 states? Can I register in my home state? Do I do something in between? I mean, I'm not asking you to give advice you can't give. But when you say risk tolerance, what does that mean?
Well, I mean, the good news for colleges, universities, and related foundations are there are available exemptions from registration, as we previously discussed. But again, there's about 18 states or so where if you're directing your solicitations beyond alumni, family and friends, faculty, or whatever the specific statute limits your appeals to, then you're probably going to have to register in those states, and many universities do. But there are also many universities and colleges and foundations that are not doing that. So you're subjecting yourself to some risk. And I, of course, as a lawyer, I would never advise anyone not to register or to make sure you're exempt. But the enforcement by state charity regulators against colleges and universities is generally pretty limited in this area. But that's not to say I haven't seen it. And I've also dealt with enforcement actions against universities and colleges for either failing to register or, not sending in a request to confirm the exemption, as some states require. To get to a couple of the questions I saw pop up, somebody asked if there was a minimal amount you can raise within a state that doesn't require registration. And the answer is there's some confusing information related to one of the exemptions that us in the industry call the de minimis exemption. And those exemptions will say something like, if your revenues do not exceed $25,000, you're not required to register. What's unfortunate is a lot of charities have been misguided and heard wrong information from advisors or others who told them, well, you don't have to register in a state unless you exceed $25,000 or $50,000 or whatever the minimum is. The problem is those exemption statutes are talking about the organization's total revenue, not revenue from the respective state. So if you raise $20,000 from Mississippi, it's under $25,000, but surely you have more than $25,000 in total revenue. So those de minimis exemptions rarely are able to be enjoyed by organizations unless they're like a kid's little league or something really small that truly has total revenue below that amount. And with respect to the question about nonprofit hospitals, there are exemptions like the educational institution exemption that do pertain to nonprofit tax-exempt hospitals and some related foundations. But again, it's state by state. They vary by state. Some of them limit it to the state's own tax-exempt hospitals and all sorts of other nuanced exemption limitations that you'd have to look at.
And let me jump in and kind of dovetail on that, and also respond to a question that talked about, what is the risk for not doing this? First of all, let me iterate that you can probably not do this, and it's kind of like speeding. You're taking the risk into your own hands, whether or not you're going to get stopped and whether or not you're going to have to pay a speeding fine. What's different here is that it's really not I don't think it's your decision to register or not. That needs to come from counsel. They need to be the ones that will tell you whether or not this is a reasonable risk to not register. The fines and penalties can be extremely high. Some are based on your total revenue. And dovetailing into what Nathan said, it's not just your gift revenue from that state, but your total revenue. And I have seen letters from Attorney General that have had multiple zeros at the end, indicating what the fine or penalty would be if they failed to register in response to a second notice or whatever it might be. So the risk is getting caught. And if you do get caught, the fines are pretty steep. And one thing to keep in mind is as states run into less and less resources, one of the things that Bob and I hear an awful lot about in higher education are gift taxes and gift fees, because state support to higher education institutions is going down. As state revenue goes down, they're looking for new and more important ways to bring in money. So you may get away with it now, but that doesn't guarantee you're going to get away with it later. And I think I'm probably covering some of the things that are on the next slide, Bob, if you want to go there.
And John, let me just add an anecdote. Nathan and I met for the first time on the phone a week ago, and I told him sort of my 25-year history with his firm. And I should preface this by saying he categorically denied anybody at his firm would have said this. But 25 years ago, I can recall, it might have even been Mr. Kopelevitz, but maybe not, saying, wait until you get a cease and desist letter from a state and then call us and we can handle registrations wherever you need to register. Fast forward 25 years, and it seems like the states have gotten a little more insistent, like you just said, and a little more aware of who's doing fundraising. And so, Nathan, fill in the blanks. You can further distance yourself from my memory if you'd like, but just how this has become a more aggressive state environment these days, right?
Right. Yeah. As an attorney, I run away from advice saying, get caught first, then we'll worry about it. So
we'll edit this part out.
Right.
Yeah. I mean, the primary, at the end of the day, you're going to be, if you're a college or university, you're going to be exempt in the majority of states. The question is, have you filed your exemption, and what do you do about the other 18 or so states where the exemption is more limited? And I guarantee you 99% of you, and I may be wrong, are probably not only soliciting your alumni and faculty. And so if you're broadening the scope of your appeal to corporations, the public at large, friends that large donors that didn't go to the school but like it, then you're probably going to need to register in those other states. And if you don't, you're just, you're putting yourself at some risk. The risk is probably limited because it's not popular to go after educational institutions that are well respected and endowed and those type of things. But I've seen it happen, and it can happen. And what puts you at even greater risk is using outside vendors like fundraisers or fundraising consultants that have to make, under state laws, the contract filing with the states, and thus alerting the state that you're not registered or haven't filed an exemption.
And that's how they put the two and two together. And I think we actually have on a slide here, one thing that I have been discovering is that states are talking amongst themselves. Bob, why don't you go to the next slide? And we'll just go over this really quick. We've talked about it a little bit. Only 9 states don't require you to do anything. 32 states offer exemptions, but require an application for exemptions. And then some of the states, but not all, will provide an exemption for your affiliated organization. Now, several people have asked about fees, and I'm not going to put Nathan on the spot and tell what they charge. Let me give you factual information from when I did this 8 years or so ago. The first thing is that we discovered at NC State, to somebody's earlier question, this was a full-time job. There were us who spent an inordinate amount of time, all the time, gathering the information, filing the information, sending it back, writing checks, respond. I mean, it was the human capital quotient was rather significant. It cost somewhere on average $1,500 and $5,000 a year if you did it yourself, but that did not include the overhead, the labor on the part of you and your staff. At the time, when we decided to outsource this, we found that the average fee was somewhere, well, the average range was between $6,000 and $7,500 per year per nonprofit organization registering for. So as I mentioned at NC State, I had the responsibility of handling this for 3 entities. My annual budget for doing this was $18,000. That does not mean, and I think I have this on another slide, that we just said, here, XYZ firm, just do it for us. We still spent 2, 3, 4 hours a week digging up this form, filling out that paperwork, writing. We still had to write our own checks in many cases. So that's the answer. I hope that speaks to the question of what are the costs.
John, did I inadvertently send you to this slide before you were ready to? There was a lot of good...
No, the other one's fine.
Okay.
We talked a little bit about this at the outset. A lot of people don't even know if this is happening at your institution, organization. It may be. It generally is a function of either the business office or the advancement office. Occasionally, there may be a risk office, risk management office, and or counsel that would be doing this. Of course, nobody wants the job. We knew that it needed to be done at NC State. As part of my job description, overseeing advancement services was compliance officer. So it naturally or unnaturally fell to advancement services to oversee this. But again, we did outsource it, which made life incredibly easier for us. I'm not going to advocate for one or the other, but it can live in any one of those 3 or 4 offices.
Do you guys know if a separate foundation enjoys the same exemptions as the educational institution they're fundraising on behalf of?
Yes.
Not all. Go ahead, Nathan.
Yeah, so I have a whole separate memo on foundation exemptions. There are not as many foundation exemptions as there should be, and probably because the legislatures didn't think about it in their wisdom. But what you typically see is educational institution exemptions in the majority of states, and then not enough of those, but many of those will also exempt related foundations. And so it's a good question. The other thing you see is, one way to limit your cost and administrative burden related to these is to identify one entity that's doing all the soliciting. You certainly don't want to be in a situation where you've got 5 different foundations all registering or filing. It's always better if you're able to make it where one organization, whether it's the university itself, and I have clients where the university itself always does the appeals. I have some where it's one foundation, but a lot of times they'll try to limit it to one entity that does all the compliance work and then accounts for all the revenue and contributions coming in. So you're not wasting, 5 different groups that are making all these filings and paying state filing fees.
Let me answer, and again, Nathan, you can jump in here and tell me how wrong I am. Somebody asked a question about they work for a health system which includes 5 hospitals. Would they have to register under the health system or per hospital? I think this is, again, with the exception of exemptions, this is akin to the NC State example where if each of those 5 hospitals does their own independent solicitation under their name, then they would need to register under their name. If all of the solicitation was being done under just the system's name, then only the system would need to register. Again, at NC State, we had the university and the North Carolina University Foundation. The foundation did most of the solicitation under the name of the foundation. However, there were a couple of occasions, especially for specific professorship programs, that the solicitation occurred under the name of the university. So both had to register. Now, what did I say wrong there, Nathan?
No, that's all right. And I've got a number of hospital clients, and some of them will register their foundations and some of them will register the hospital itself. But they try to avoid duplicating the registrations as an administrative burden and cost situation if they're able to do that.
And one of the things that we did look at, as I mentioned, we had these 11 different foundations at North Carolina State is, for all of them, were there any that really didn't do much in the way of fundraising, in which case then they didn't register. Although right. I think it's only one of our foundations that actually was true for.
Right.
Now the slide that you're seeing right now, I think I kind of touched on, can we pay a vendor? Can we give our hard-earned money to Nathan and just say, here, take care of it? Get it? And the answer is, yeah, not really. But they do an incredible amount of work. And again, I'm not speaking for Nathan's firm, but there's still going to be some touch points. You will have to every year provide all of the updated information to the vendor, all of the updated board information, the new 990. You won't have to give them another Form 1023 or original IRS determination letter. They're going to keep that on file. I don't know. Again, this was 7-8 years ago. I still, even though we turned everything over to a vendor to take care of things for us, we still had to cut checks, at least in some cases, directly to the particular state that was asking for some money.
Nathan, there's a couple things I should probably apologize for on behalf of my friend John on this slide. One, lumping you into the category of vendors.
Sorry.
And two, telling people there are plenty to choose from. But can you talk a little bit about that relationship and how you work with individual institutions?
Sure. We're a law firm, so we provide registration services for maybe hundreds and hundreds of all different types of nonprofits. Most of them are nationwide filers. Some of them have many exemptions available to them, like universities or university foundations. And our process is very seamless. We try to make it as least painful for our clients as we can. We have information on a new client questionnaire that they complete. We use that information to populate all the state forms where they have to register. In the cases of a university that might enjoy exemptions, we confirm or assist them in drafting exemption requests for those. And then after the exemptions are obtained in the states where we believe they can enjoy them, we assist them with each annual filing going forward. And again, in the University College Foundation situation, you're looking at usually about 18 states where they have to register annually if they have broad-based appeals to different kinds of folks. But there are non-law firm vendors out there that also perform these services. Of course, I'm partial and think we have a lot more value since we can deal with legal issues that come up, whether it's state required disclosures you have to make under state law in your solicitations, or whether there's certain contract language that has to be in the contract between you and your vendor, fundraisers, and fundraising consultants. We assist with all those type of things as well.
Great. Thank you for that. I don't often have the luxury of having somebody available to verify the information on John's slides. This has worked out great for me.
For once, you know, I don't lie about everything. Okay, so next slide, Bob.
We're there.
We're nearing the final innings.
Yeah, this is new. Can we just plead ignorance?
I'm sorry. I was looking at my own slide deck. That's why I said, Bob, come on, move. Again, we've talked about risk. We've talked about that it's really not your decision unless you happen, sitting on this call, are counsel for the nonprofit organization. If you choose to plead ignorance and ignore the rules, then that's your call, but it shouldn't be your call. It should be the call of your attorney to do so. And of course, depending on how broad of a net you cast for doing your fundraising, if you are a smaller regional organization and most of your donations come within 1, 2, 3 states within 500 miles of where you are, then you clearly don't need to think about registering in the state of Hawaii, for example. You only need to register in those states that you have a fairly good relationship with constituents that you will be cultivating and soliciting. So again, how small of a net you cast will play into whether or not you want to plead ignorance and hope that you don't get caught. Of course, I think all bets are off when you do get caught. And again, NC State had been caught. It was not a financial cost because, and Nathan, maybe you've seen more recent, because my experience was 8-10 years ago. The first letter that we got from an attorney general essentially said, you know, put up or shut up. You know, you need to register or else you can never, ever solicit again in our state. I never received a letter from an attorney general that said, you now owe us this amount of money because you didn't register. Is that still about correct, Nathan?
So there are states you will never be issued a fine, knock on wood. At least historically, we've never seen that. But then there are some states that are very aggressive. So it just depends on the state. I mean, some states like Mississippi and Pennsylvania are extremely aggressive, but then you have other states where you don't typically see any enforcement action in any situation related to charitable solicitations. So it really just is dependent on the state. And what makes it even more complicated is that most of these agencies that regulate charitable solicitations are elected official positions. So the Attorney General's office or the Secretary of State's office within the state. So what happens is that some years one state may be very aggressive and then they get a new administration and you don't hear from them for a few years. And then a few years later, they're aggressive again. So it's almost like, you know, trying to figure out how aggressive the state is at any given time, and it changes over time as well. But most of the times for the aggressive states, the penalties are based on how much you've raised in the state while not registered when you should have been, if you should have been, how many solicitations you've directed to the state during that period of time, and how much you've raised. And then the state may come up with some kind of monetary penalty related to those violations.
Nathan, there's a couple of questions in the general category of when you're working with a third party, you hire somebody to do your telemarketing or maybe hire somebody to be your mail house, and maybe they got you registered, you know, in a bunch of states, but now we don't work with them anymore. And I think I know where this is going. It's still your risk tolerance independent of who you're working with. But when you've got a third party involved, do they have their own, they have their own requirements for needing to be registered, right?
Right. So there's 3 different types of vendors that also have registration obligations under the state charitable solicitation laws. The first, obviously, is what we've discussed, the charitable organization's own obligation to register, or confirm an exemption. The other type of vendors are telefundraisers, which are called professional fundraisers in most states, or professional solicitors. California is the only state calling them commercial fundraisers. And fundraising consultants or fundraising councils have filing obligations in about 28 states. And those vendors have to register independently and separately from the charity. So like I said, the professional telefundraiser would have to register in 45 states to the extent they're soliciting contributions in those states. And they also have the obligation of entering into a contract with the charitable organization that contains certain specific language under state laws. And then that vendor has to file the contract with the states. And the first thing the states do is they check to see if the fundraiser is registered, and they probably are since they're filing the contract. And then they check to see if the charity itself with which they contracted is registered. And that's how charities that aren't registered or haven't claimed an exemption get in trouble, is that the fundraising vendor will get a letter from the state saying, thank you for this contract. Unfortunately, you can't perform services in our state related to this contract because X charity is not registered. And then they might send a copy or a letter to the charity saying, we received a copy of this contract, you're not registered, register immediately. Or in the more aggressive states like Mississippi, they might say, have you solicited here? How much did you raise? We're going to impose a penalty against you.
Boy, don't let your alumni move to Mississippi is what I'm hearing here. and so if you're working with a third party, like a telemarketing company, it's important to know they've got their own sort of hoops they have to jump through. And even if you stop working with them, you still revert back to what your own risk tolerance level is for yourself as a charitable cause unto yourself. Yes. All right, John, what do we got left here?
I think you can go to the next slide. And this is also part and parcel of the registration requirements. And this is oh my God.
Go ahead.
So not only do states have registration requirements for you to be able to solicit, but some have very, very, very strict and specific requirements for disclosures that you must put on your solicitation pieces. I think these are all of the states that at least I'm aware of that have a requirement. I'm going to talk to Nathan about this in a second, but Bob, show the next slide as to, so this is the requirement for North Carolina. And, you know, Christina, like New York, North Carolina requires that the statement be printed in 9-point type and made conspicuous by underlining or a border or bold type. You have to have that whole thing that's in quote. Bob, can I share my screen?
We can try.
No, don't worry about it. This is a short statement compared to like New Jersey, which is absolutely bizarre. And I'm thinking, okay, so many of us solicit in all of these states. And so does that mean that we have to have all of this language on our direct mail piece, which would mean it's going to be, like 3 feet long?
It's like buying a pack of cigarettes.
Yes. So, one thing that I have done, and this is where, Nathan, you can tell me that I've broken the law. One thing that I have done, and it seems to have, well, it's worked only because no one has fined us, is on the solicitation piece, put a statement that references a website, a URL, as all of the disclosure statements that are required listed. So if somebody wants to see what the requirements are, they can follow the link. Obviously, they'd have to type it in if it's a direct mail piece. I honestly do not see how any organization could economically print all of the unique disclosure statements on their direct mail pieces. Now, Nathan, what's the right answer here?
I can't wait to hear what Nathan has to say.
Well, it's the number one complaint I get from advancement and marketing folks related to charitable solicitations is, do we have to put this? It's so ugly. And then we have a template that we provide all of our clients that we update each year to make sure it's compliant. And they always, they'll make it smaller, change the font size. And so I always make it a point saying, we're not trying to be cute when we put this template together. If it's underlined, then keep it underlined. Or if it's bolded or if it's in a certain font, keep it that way. Because, we're not being creative. We're just following the state laws. And so the good news for this particular group of audience here, the university, colleges, and foundations, is if you're exempt from registration, then generally these disclosures would not apply to you if you've confirmed that exemption with the respective state. You'll notice, for example, that on the North Carolina disclosure here, it talks about getting a copy of your license, and a lot of the state disclosures will say get a copy of the latest financials. Well, that would not be the case if you're exempt from registration, because you would not be filing the 990 or financials with the state. So most of the time, if you're exempt in a state that requires a specific disclosure, you're not required to put that specific disclosure. But again, it depends on the particular state statute and what exemption you have. But again, I see a ton of enforcement action related to failure to make disclosures, and it's low-hanging fruit for the state regulators. North Carolina, this is some time ago now, I'd say maybe 7 or 8 years ago, was notorious for imposing penalties against organizations that either failed to put the North Carolina disclosure, or in one case, believe it or not, I saw someone fined for not having it in 9-point font, but 8-point font. And so you've got to be very careful to make sure that you have the appropriate disclosure and in the appropriate font. I saw in the chat that somebody asked if New York had a font size requirement, and they do. It's 10-point font. So most of the time we advise just put the entire disclosure in 10-point font, because that's the biggest requirement. With respect to providing a URL link, the state regulators don't like that because a lot of them will take the position that it's not clear and conspicuous. And a lot of these statutes will say something like, a charitable solicitation must have the following disclosure, which is clear and conspicuous. And if it's, and the state regulators will say, well, if it's a URL link that they're never going to go to, then we don't believe it's clear and conspicuous, and we don't believe you comply with the statute. So there's risk in doing it that way.
So I can have the elevator certificate of inspection on file in the office, but I can't refer you somewhere else for my solicitation statement.
Right. The converse argument to that is, if you do put the entire disclosure, like anybody's going to read it anyway, but they like to see their disclosures there.
I know we've hit the top of the hour. I want to address questions, Nathan and John, if you guys still have time. John, I think, has a couple more points that he wants to make. Nathan, are you okay?
Yes. Yeah, sure.
Okay. John, do I have to look at this slide anymore?
No, you don't. Get rid of it.
Oh, we're there anyway. And we have Nathan's information too. Okay, I know we've all been sort of keeping our eye on the chat, but let's see if there's other questions.
Well, there was one question about a specific state and how aggressive they are, and the answer is it depends. So it depends on who's in office. Broke the state is, I think. The question specifically that was posted dealt with Ohio. They do have a disclosure requirement for the direct mail piece, but it's a standard one. It just requires that you put the name and address of the charity on the disclosure statement. I don't know how aggressive one state is over another. I cannot remember which states I received nasty grams from when I was at NC State. I do remember getting one from Pennsylvania and another one. So I guess they have continued to be pretty aggressive, but those weren't the only two states we got letters from.
I think this is my favorite question. Somebody asked, if I want to now become an upstanding citizen and start registering this point going forward, am I at any risk of any state saying, let's just see what fundraising you've done previously?
Yeah, and that's an excellent question. The good news is the majority of states on the initial registration filing don't ask anything about past conduct regarding solicitation. There are a couple of states like Utah and Pennsylvania that do ask the question. And so if you do answer it truthfully, which of course we would advise you to do so, that you might have to take some medicine, especially with respect to Pennsylvania. But the good news is, that, again, the vast majority of states will not impose a penalty against you for initial registration if you haven't registered in the past. Again, a couple states will ask about it. I think that the risk for a university or college would be even more limited than your average charitable organization, just because, again, it's not popular to come after educational institutions. These are elected officials. These are just my opinions of what I've seen, and obviously doesn't mean that won't be the case. That will be the case going forward. But I think it's always better to comply and take that risk than just not complying for eternity, which I think puts you at even more risk.
Yep. Agreed.
A couple of questions that are sort of location specific. Our foundation and alumni association are separate 501c3 entities. The funds the alumni association raises come to the foundation. Do they have to register separately within the states to solicit?
So I can address that from what I had to do at North Carolina State, and the answer was yes. Because the Alumni Association, and there are different rules, I think, Nathan, for membership-based organizations versus educational institutions. The money that the Alumni Association raised ended up going through the foundation, but it was the Alumni Association who was raising money in the name of the Alumni Association. It didn't matter that we were using the foundation as a bank.
So, and again, you're right, there are membership exemptions, and that brings us to a whole host of other applicable exemptions. And membership organizations are also able to enjoy some exemptions, which may or may not apply to an alumni association, depending on the particular state statute. But when you're trying to figure out who's registering with respect to a charitable solicitation, you want to look at who is counting the money for purposes of their Form 990 or tax document, and who's issuing the tax receipt. That's really the entity that's soliciting the contributions. So that's one thing you'd have to look at. I know sometimes it gets confusing, especially in this context. I've even talked to universities that weren't quite sure which entity was logging the revenues because of the multiple entity situation that you described, similar to North Carolina State.
So in a similar question to that, I work for a health system with 5 hospitals. Does the system register? Do all 5 hospitals have first? We handled that already.
Yeah, we did.
Sorry. Okay, I think, by the way, so, I just suffered that painful slide of the disclaimer that goes on mailings. Why? So I'm not looking for trouble, but so far emails don't have the same restrictions. I mean, we're in a multi-channel fundraising world now, Nathan, but I shouldn't go looking for trouble. Is that right?
So it's interesting you brought up email. What you want to keep in mind is that most of these statutes were drafted and passed from like the 1950s through the 1980s, when the only forms of fundraising were related to mail and telefundraising. And so now we're in a situation where we're trying to figure out, how do these disclosures and these registration requirements and laws apply to emails or text to give and those type of things? Now, what we're seeing from the state charity regulators is they treat mail in practice just like direct mail. So if you send an email to me and I'm in Nashville and you ask me for money, then most of the states are going to take the position that you have to register prior to sending me that email. Now, what's in the Charleston Principles is, whether or not you know or should have known that you directed an email to Tennessee. But, how do I know? I mean, it all depends on what kind of donor information you have. If you have my name and address and then send an email to me in Tennessee, then you probably should be registered prior to sending that email. If you only have my name and email address, then maybe we could argue with the state, even though the state's going to take the position you should have registered. Maybe we could argue, well, you didn't know you were directing it to Tennessee. So this situation is still a gray area, but I will tell you that the states in their enforcement action and in their positions is that you need to register prior to directing an email to a state. But the real rule probably is if you should know or should know that you're directing it to a particular state, you need to be registered in that state. So it's better to be safe than sorry.
You wind up in the odd position of having to argue your own ignorance about your prospects, don't you?
Right. And you have to say, well, I didn't know. This person gave $100, but you really only have their email address. I mean, that's hard to believe. Didn't they want a tax receipt and everything? So.
Yeah. Okay. Why don't John, anything else that you
Nope, I don't think so. I think we covered the waterfront, and I'm sure have bored everybody to tears.
Nathan, any other subject that we sort of breezed by that you want to read into the record, as it were?
I don't know. Do you? I guess we could talk about the Schedule B situation that's going to go before the Supreme Court or not, but I don't know. I don't think that really applies to many of the colleges and universities because I think they're exempt in the states that are demanding Schedule B. But one of the current issues that's about to go before the Supreme Court this summer is that the states of California, New Jersey, and New York for many years did not require Schedule B. Schedule B is part of the Form 990 where you list your major donors, those that give usually above $5,000. And so historically, when you make these charitable registration filings, you have to provide your Form 990, not including Schedule B, because you obviously want to protect the anonymity of those major donors. And the IRS doesn't even require you to provide that information to the public when they ask for the 990. And so about 7 or 8 years ago, California started requiring Schedule B to be a part of these registrations. Charities went nuts over it. They didn't want to provide it. They were worried about the safety of their donors or their home addresses on there, or that other organizations might hijack that information and become donors of other competing organizations. And so that issue is going before the Supreme Court. And it's a conversation I've had about, 1,000 times in the last years or so, because it's a major issue regarding freedom of association, protection of donor information. So that's the hot topic right now.
Excellent. And thank you for that. And thank you for all this. John, I think we came to the right guy.
We obviously did. Thank you so much, Nathan.
Well, thank you all for having me. I hope that everybody's not sleeping.
There's his contact information, and I can vouch for the fact that that firm's been around a long time, almost as long as John and me. Yeah.
So, right. Well, maybe you, not me.
Nathan, thanks very much again. Enlightening on several levels, and whatever your risk tolerance is, right? But appreciate you sharing all the information, and appreciate everybody who joined in for our chat. Thanks for being here. Come join us at the Meeting of the Minds in a couple weeks. And Nathan, thanks very much again. Bye-bye.
Thank you.